Hi, Crime Junkie Jurors. So there have been a lot of questions about the rulings from the judge this past week on the two issues with the experts. One is the changing of the report from the prosecution's expert and why it should or should not have been allowed. The other is Brennan's request to have his expert continue testing and working on analysis and things like that so that he can come back in and rebut ARCA's testimony. First, let's look at the changed report and why that matters. So here's the deal with this one. Not all clocks are created equal, right? Both sides have looked at the clock drift issues and the data provided from the different reports and have made their conclusions about which clocks are right and which clocks are wrong and by how much. This includes 3 clocks that are in the phone and a clock in the Lexus SUV. Now, this was brought up in last year's trial. It's in the reports from experts on both sides for this year's trial. It's basically common knowledge that everyone agrees on that there is some kind of clock drift. Now, what they don't agree on is the interpretation of the clock drift. The prosecution's expert, Ian Whiffen, said in his testimony that you cannot rely on just one of the clocks. You have to have an analyst actually look at it and determine how to read or interpret that information. Both sides have done that. But here's the issue. The discovery deadlines for the prosecution are due before the defense, right? They have to get all of their information for the trial in before the defense, because once they've turned over everything that they have, then the defense has a chance to see what experts or witnesses the prosecution is going to bring in so that they can plan their defense to basically rebut the prosecutions. So the prosecution has Dr. Welcher coming in as a crash reconstructionist. Now, during the cross-examination of Ian Whiffen, the Cellebrite expert, on day 6, defense attorney Robert Alessi specifically asks Whiffen about the Aperture report from Dr. Welcher. He asks him if he's aware that those experts from Aperture, including Dr. Welcher, actually used his data when they created it.
Mr. Whiffen, are you familiar with a firm called Aperture?
I'm vaguely aware of them. I've heard of them once.
Are you familiar with a person by the name of Dr. Judson Welcher?
I'm not, no.
But you're familiar with the firm Aperture?
I am.
And do you know that the Aperture firm is working on this case?
That's the only reason I'm aware of this company.
Right. And do you know that the Aperture firm has used your data in your report? Do you know that?
I believe I saw something about that.
You believe you saw something, or do you know that they've used your data for a report in this matter?
I recall seeing a report. I don't recall whether it was my data that was being referenced.
Do you recall seeing a report from Aperture?
I do.
So you reviewed a report from Aperture?
Several months ago, yes.
And did you read the whole report?
It was a PowerPoint presentation, I believe?
Yes.
Yes, I reviewed it.
And you recall reading that entire PowerPoint presentation?
I don't recall what it said, but I remember reading through it.
Fair enough.
So Whiffen acknowledges that Aperture used his data, and the trigger point that they have for the collision is at 12:31 and 38 seconds. And Whiffen acknowledges that he has seen this. Now, Dr. Welcher does have a clock time range for this, but that range is from 12:31 and 38 seconds to 12:31 and 43 seconds. So that entire range is still all before the final time that John O'Keefe uses his phone for the last time, meaning that doesn't work with the Commonwealth's theory. So Alessi bases his remaining timeline questions with Whiffen on all of this, on him acknowledging it, and he's pointing out that the times that Whiffen has in his report about when John uses his phone are all after the time that Aperture says the impact was supposed to have happened. This was a very big moment for the defense. They've based their entire defense strategy on these timelines not adding up. So now Dr. Welcher has handed in a new report saying that the trigger time is actually at 12:32:16, not 12:31:38, which now basically just makes it align with Whiffin's testimony and the rest of the data. So this is brought up on day 16, and Alessi explains why the Aperture experts said that they wanted to change the timing.
Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago.
So the question then becomes, why are they changing the report now while we're basically this far in? We're nearly done with the trial. Alessi says the prosecution has accused them of trial by ambush like over and over. But he says this is the definition of ambush.
Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its, the information of Aperture that has been extant before the May 8th date of the report. Thank you.
So there's a lot of back and forth over 2 days about this. So I'm going to try to break it down into what we know based on what both sides are saying. Brennan says that he has always acknowledged that there is a clock variance and even mentioned it in his opening statements. And that's true. Neither side has disputed this clock drift. The defense hired an expert by the name of DeSogra to look into Dr. Welcher's conclusions and report that was given, including the clock drift stuff. And DeSogra provided a report of basically kind of his rebuttal to Aperture's information, which was turned in before the trial started. His conclusion was that John O'Keefe's phone ran late. And because of that, he said the prosecution's timelines will never align, meaning what Whiffin is saying and what Dr. Welcher are saying don't line up, even with the clock drift. So the defense has planned out their strategy based on that, including the cross-examinations that they've already done in the trial, like Ian Whiffin, Jen McCabe, Jessica Hyde, and even deciding not to cross-examine Trooper Garino about the data extractions that he did. Here's where it gets really messy, because Dr. Welcher has now turned in this new conclusion on an amended report that changes what he said about the time drift, now aligning it with the phone data from John O'Keefe instead of contradicting it. And Alessi argues that this is in response to Whiffin's testimony, which Dr. Welcher is not supposed to be watching because witnesses aren't allowed to watch testimony before they take the stand. Changing your testimony or opinions based on what someone else says is the exact reason that this isn't allowed. But the issue goes far beyond violating sequestration orders. Brennan says that Dr. Welcher looked at the defense expert DeSorga's report, the one where DeSorga concluded that the time drift variance showed the prosecution's timeline would never line up. And Brennan says that Dr. Welcher just looked at that and saw that DeSorga was wrong, and that that's what made him start kind of digging into this whole time drift thing deeper. So Dr. Welcher then looks at the Lexus SUV data and compares it to the Waze data from John's phone. And he says, based on that, as in based on information that he's had since October when he was hired, he was now suddenly able to, well, now that the trial's almost over, he's suddenly able to come to a determination that he wasn't able to come to before. And somehow now he's able to line up the car and phone timelines because he has now figured out how to calculate the clock drift and can line it up with the phone data. Now, there are so many issues with this. One is that Brennan contradicts himself multiple times when making his arguments here. First, he says he asked their expert to review the defense expert's report.
We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorbo was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong.
Okay, he says he asked his expert to do this, but then just over 1 minute later, he says he was surprised to receive this report.
We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever.
So which is it? One thing that Brennan mentioned in the voir dire of ARCA is that experts don't work for free. So I don't know. I find it kind of hard to believe that his expert just decided to look into this more and do some extra work and has now somehow found this formula that gives him this new time, and he just surprised Brennan with his new report on it. And then Brennan says that his expert was looking more closely at this because he was looking at the defense expert's report and determined it was wrong. Okay, but the problem with that is that the defense expert's report was in response to Dr. Welcher's. So the defense expert says, hey, here's what I think about your report and why. And now Dr. Welcher is changing his report? How is that allowed? But the contradictions don't stop there. Brennan will also make the argument for Dr. Welcher to be able to come back and do a rebuttal, which we'll get to in a minute. But part of his argument is that Dr. Welcher hasn't had time to look at ARCA's information that they turned in on May 7th because he has been away and unable to complete any of this work. And he couldn't even get ARCA's report to Dr. Welcher until May 9th because of that, which is really interesting since the report that Dr. Welcher just turned in was dated May 8th. So he's doing work for you on May 8th based on information that he had access to for months, but he couldn't be bothered to look at the most recent report from ARCA yet. How does that logic make sense? How does that timeline make sense? And Brennan insists that nothing has changed, that the data is all still the same, which is true. It's not the data that has changed. It's his expert's interpretation of it, and that is a very big deal. So Alessi asked for the report to be excluded. He says it's too late for it to come in at this point. But he says if Judge Bev won't exclude it, he wants it to at least have a voir dire so that he can ask the expert questions about this, about him changing it and why he changed it. And Brennan says no, he shouldn't be allowed to have a voir dire on this because he has no good faith basis for it. And if you put this in perspective, look at it like this. Brennan has asked for a voir dire for defense expert Dr. Russell, the one who was testifying about the dog bites on the arm. Dr. Russell had already had one voir dire and had already testified in the first trial, but the judge still granted it. Brennan asked for a voir dire of Dr. Wolf, who had already done one voir dire and had already testified once before, and the judge granted it. Brennan asked for a voir dire of Dr. Rentschler, who had already done one voir dire and had already testified once before, and the judge still granted it. In fact, the judge overall has granted all but one of the Commonwealth's requests for expert voir dire. But for the defense, this is now the 6th expert voir dire that they have requested, and the judge has denied every single one. But even though the defense has based everything on what this original report from Dr. Welcher said, now the judge is allowing the change to come in, and the defense just gets to cross-examine him on it, which, I mean, that's literally what's allowed anyway. So now for the other issue, which is probably even worse. So the defense's experts from ARCA were allowed to take a look at Dr. Welcher's report and do an analysis on it and basically kind of give a rebuttal for the defense about Dr. Welcher's conclusions and what they think about it. Now, Brennan wants Dr. Welcher to be able to basically come in and testify to his own conclusions. And even though ARCA hasn't testified, he will be able to kind of preemptively address everything that ARCA had in their original report. But here's where this one gets tricky. Brennan is asking to have Dr. Welcher basically be able to keep working and keep testing and doing analysis so that he can come back again after ARCA testifies and basically give a rebuttal to any of the quote unquote new information that they give. Here's why this is a problem. In order to have a rebuttal witness come testify, it has to be justified by the need to challenge evidence or testimony that was not anticipated during the initial presentation of the case. That is not the situation here. The quote unquote new information that ARCA is testifying to is not actually new information. This is all in response and rebuttal to Dr. Welcher's report. A rebuttal witness admissibility is supposed to be based on whether or not the testimony is genuinely rebuttal in nature. And since ARCA is responding to Dr. Welcher's report, Dr. Welcher coming back again is not what qualifies as rebuttal in nature. And unless he tries to explain this and its importance.
But there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance.
So think of it like this. Why should Dr. Welcher need to do a bunch of testing and analysis to rebut someone who is rebutting his testing and analysis? He should be able to just confirm why his testing is trustworthy. But is it? Brennan has a pattern when it comes to experts. Instead of debating facts, sometimes he tends to go straight toward insults. He did it with Dr. Russell. He did it with Richard Green. He did it with Garrett Wing, Michael Easter, and especially with ARCA. And this is no different.
Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses.
So here's the issue with that, though. Brennan says his expert found all of these ARCA failures and his expert is the best, et cetera, et cetera. But this is the same expert that had all of the phone data information since October and apparently couldn't figure out this clock drift thing until like a week and a half ago. And this is the same expert who didn't know the difference in gigabytes and gigabits. And based on his own misunderstanding of how it worked, had a whole report about all the information that was being withheld from Karen's SUV black box data, which of course wasn't accurate. So given just those 2 big mistakes already, and the fact that we've heard his presentation relied on contested witness testimony, I mean, how reliable is this expert? And with all of those issues already, how do you expect us to think that he's capable of pointing out failures from ARCA? I guess time will tell. Let me know what y'all think in comments. Although this seems to go completely out of the realm of what seems like it should be allowed, the judge allows this and said she's going to put a limited scope on it. Now that's very open-ended, and I'm going to be interested to see what that scope is, because a rebuttal is allowed by prosecution, but like I said, it's limited to what the defense presented that wasn't expected during the case in chief. And if the scope isn't narrowed correctly, it could be a huge appellate issue. I hope this helps break it all down a little bit to make it easier to understand, and be on the lookout for episode 53 of 13th Juror Podcast, where I'll have kind of an extended version of this explanation along with a breakdown of the rest of the week's happenings in court. And don't forget to join us live for court every day, 9 a.m. right here on Crime Junkie Jury.